Good morning and welcome to our Saturday morning webinar. I'm Chris Denicolo filling in for Alan Gassman this morning on this July 8th. Hopefully the weather's a little bit better where you are than where we are here in Florida, where we have heat indexes that have been repeatedly in the triple digits. So we'll try to keep this presentation as hot as the temperature outside here. And today we're going to talk through nuances in Florida law that might not be evident, some of the more lesser known nuances for Florida law. And those of you who have seen the title, it's a ripoff of Jeopardy with the $500 category of Florida estate planning and tax law nuances. So hopefully we'll get to some of the more difficult topics. But, you know, by and large, a lot of the things that we're going to talk about today are pretty important and are somewhat simple to grasp, which is a very good thing. It's just that they may not get as much fanfare as, say, some of the more widely known things in Florida law, or better yet, some of the items that we will talk about today are to clarify any confusion and to demystify things like homestead and Florida tax law to make it easy to understand so that we don't fall into traps for the unwary. So without further ado, I'm going to jump right in to the number one thing that I typically see that's kind of glossed over by a lot of planners and clients alike is how to become a Floridian. And I get people who reach out to us all the time and say, what do I do to become a Floridian? How do I make Florida my home? What does Florida require? And the short answer is not really much. Florida doesn't necessarily care if you are a Florida domiciliary, because Florida, as you will know, does not have a state level income tax and has a somewhat limited tax system. But in places like California, New York, Washington State that do impose state income taxes, there are a number of criteria that those departments of revenue look at when they review as to whether an individual has fled the state from a domicile standpoint. So the one thing that's not really well known here is that Florida does not have any certain sort of criteria to become a Floridian. Having said that, here on slide number 4, we have a variety of factors that can be very helpful in establishing whether a person has moved to Florida. And I will make this comment. If you have a client, or if you yourself are moving from California, Washington, New York, or some other state that's not Florida, I would suggest going on to the local Department of Revenue website and seeing if the Department of Revenue in that state has any criteria or factors that they consider in determining whether you have left as a resident of that prior state. I know Washington, for one, has certain criteria that's, you know, they look at, that the state looks at to determine if a resident has left as the state as a resident, has become a resident of somewhere else. There's been somewhat of an exodus of individuals leaving those states to come to Florida in hopes of reaching a lower tax environment, a state where the weather by and large is nice. I wouldn't say that this time of year, but nevertheless, you know, those other states, really it's their criteria that are going to be important. That's something that's not really understood. It's not really brought about when we talk about coming to Florida. I also wanted to mention the idea of a Florida resident or someone who's moving to Florida who maintains a home in their prior state of residence. That can be a really big trap for the unwary. I know Washington State has that as a set of criteria as to whether someone has left the state or not. And I believe California looks at that as well. We've had clients who own a large 4,000 square foot house in California and say, I want to be a Florida resident and I want to live here for a few months out of the year, and they get a much smaller condo or a much smaller house. If they keep that California residence, then the California Department of Revenue is not going to look too kindly upon that. So I would suggest, making sure that we're aware of that aspect of, it's not necessarily Florida law, but it relates to Florida law. And it's very important for individuals who are moving to Florida or who want to move to Florida in the near future. Another thing in Florida that's really not understood is the idea of a probate, right? We have a probate system in Florida where individuals who own assets in their individual name and die, their estates will have to, or their personal representatives, I should say, will have to go to a local probate court to open up what's called a probate proceeding in order to pass those assets from the client's estate to the intended beneficiaries. And sometimes an estate is opened simply to pay creditor claims or to handle creditor claims in a manner that would not otherwise apply. You know, I want to make it clear that there really isn't a requirement to open a probate per se. And, you know, it's really opening the probate to transfer assets out of the individual's estate. And one common situation that we see is an individual who dies, a resident of another state, but owns real estate in Florida. And as a result of that real estate ownership, a probate proceeding is necessary to transfer ownership to the heirs of the beneficiary. One little trap that I typically see here is that, you know, unless there's a need to transfer the asset out of the estate, maybe it's best to wait until 2 years after the decedent's death to open this Florida probate. And this, by the way, can be referred to as an ancillary probate because it's, you know, the person is not a Florida resident when they die, but they own property in Florida, which creates this requirement for a probate to transfer the asset. But if we wait 2 years after death, then any creditor claims against the decedent's estate are barred under Florida statute, and a more streamlined summary administration can be effectuated rather than a formal administration here that I've mentioned here, where a personal representative is appointed and there are reporting and disclosure requirements with respect to creditors and otherwise that frankly don't exist under a summary administration. A summary administration can simply pass ownership of the underlying assets directly from the estate to the beneficiaries, and it can be a much easier way to proceed. And as a corollary, this type of probate mechanism can be available even for Florida residents. In fact, if you have a Florida resident who has died and there's really no need to open a probate initially because most of the assets are outside of probate, or maybe, you know, it's best to wait because the decedent has creditors. Well, if we wait for the decedent's until the second anniversary of the decedent's death, any creditor claims are barred, including any creditors that the personal representative should have known. So if, for example, I die owing Alan money, and my personal representative knows that I owe Alan money, well, under Florida law, if I open a probate, or if my personal representative opens a probate, not sure how I could open a probate for myself, but if my personal representative opens a probate, they have to give Alan notice of the probate. But if no probate was opened until 2 years after death, then the claim that Alan might have against my estate is barred, and there isn't a requirement that that I open that probate. Now, Alan, of course, as a creditor, could open the probate and move the assets forward in a manner where the creditor claims could be paid, but that's another little nuance that's not easily understood. Now, this ancillary probate that I've referred to is just really a fancy name for a probate open in an estate other than the domicile's estate. Another little trick is that you don't have to have an ancillary probate if you're not a Florida resident. In Florida, you can open a regular probate in any county in which the decedent owns property, even if the decedent doesn't live there. So if I'm a New York resident and I own property in Pinellas County, Florida, and I die, my personal representative can open a probate in Pinellas County. Doesn't have to be ancillary, because with an ancillary probate, you typically have to open a domiciliary probate in another state. So you'd have to open a New York probate for me, have the personal representative appointed as executor there, get those documents authenticated by the court, and have that open the ancillary probate in Florida. The alternate approach, which could be even easier, is just having a probate open in Florida in Pinellas County, without regard to opening a New York probate if it was not otherwise required. So very little discussed about this, but it's certainly something to be aware of, and it can streamline probate proceedings. Now, of course, we all want to avoid probate, and it's not that Florida probates are the worst thing in the world, but they can be cumbersome, expensive, and avoidable. And I think for those reasons, it's important while we have clients doing estate planning, we want to make sure that living trusts are used, owning limited liability companies instead of outright property in other states, so that you wouldn't have to go to another state to open a probate, and then maybe using something like a ladybird or life estate deed, which is a great probate avoidance tool. That's something that we do a lot of here, because probate can be, as I said, cumbersome, expensive, and avoidable above all. Another little trap for Florida estates, to be a personal representative in Florida, you have to be either a relative of the decedent or a Florida resident if you're an individual. And if you're a non-resident, you have to be a relative that meets these categories here in 1 through 4. But one thing that's missing are cousins, or in some instances, in-laws. We've had situations where sister-in-laws couldn't serve as personal representatives of the estate of their brother-in-law in Florida, and we've had to have someone step in Florida as a personal representative. So that's really important, especially for those of us out there who are Florida estate planners and who are naming individuals to serve as personal representatives under a decedent's document, or a future decedent's document, as we would say. So a ladybird deed, as I mentioned earlier, is another commonly used tool here in Florida, but it's often misunderstood, and it sometimes is referred to as a contingent remainder deed. And what this involves is having someone transfer ownership of the property of real estate, but keeping a life estate, the right to reside on the property for lifetime, and also keeping the right to change the remainder interest on death. So in essence, it functions like a trust instrument, almost like a revocable trust instrument baked into a deed. But with that said, it's much easier to plan for. It's much easier to incorporate. We typically use these for individuals who have property in Florida and maybe don't have survivorship provisions or any other outside of a trust instrument type of passing of assets. But a really important nuance that is widely used and can certainly amplify your practice. Okay, so move on to the next topic here. And Florida has this reputation of being a debtor's haven, in that there are a variety of creditor protection exemptions under statute, and of course, homestead. And we'll get into that in just a minute. But a lot of these exemptions are misunderstood and misapplied. Firstly, Florida has this really robust homestead law, but the homestead is not necessarily the end-all be-all, especially if bankruptcy is an option, because last-minute transfers into homestead can be used for Florida creditor protection avoidance purposes, but not for bankruptcy avoidance. So under the 2005 Bankruptcy Act, there was a new law passed where someone who wants to use the Florida exemptions in bankruptcy will not be able to do so unless they've lived in Florida for 730 consecutive days, and if their protected homestead has been owned by that individual for at least 1,215 days. And that's a really important distinction for individuals who want to move to Florida to take advantage of these creditor exemption provisions here. And you'll see, this is a brief summary of the statutes that we have. The chapter 222 of the Florida statutes provide for a wide array of exemptions. They protect retirement plans like IRAs, pension accounts, 401ks, permanent life insurance, 529 plans, annuity contracts, wages for up to 6 months. These are all really, straightforward exemptions on their face. But there's a lot of nooks and crannies here, and we can spend the entire hour plus going over these various nooks and crannies. Alan and attorney Mike Markham have written a really nice book on Florida creditor protection planning, and they explore a lot of the nooks and crannies when it comes to creditor protection planning and all of the various machinations of what can occur relative to these scenarios. Now, there are a number of cases out there that are presented in Mike's and Alan's book that I would encourage you to take a look at if this is something that's important to you or to your clients. But the moral of the story here is that it's not as cut and dry as it appears, particularly when it comes to wage accounts and when it comes to protecting assets under homestead. And the homestead in and of itself is this behemoth of area in Florida law. It's like a Gordian knot for practitioners. It's something that, even the most experienced Florida practitioners are well served by going to the statute or going to the constitutional language to see how this applies. In a nutshell, the Florida homestead protection is absolute as to any dollar amount. So if you own a penthouse in Miami Beach, Florida, that's worth $35 million, as long as it's under a half an acre in a city, it's protected from creditors. Doesn't matter how expensive it is. On the other side of the coin, if you own a homestead that is outside of a city limit and is more than 160 acres, less than 160 acres, then it's protected from creditors. That again has no dollar amount cap, but the important thing here, the nuance to look out for, is to make sure that the property in question is understood to be either in a municipality or outside of a municipality. And it's very important because the half an acre size versus the 160 acre size is such a huge distinction that many clients who have potential creditor protection issues may look for houses only located outside of city limits. So it's very important to understand this. Now, to be availed of the homestead exemption for creditor protection in Florida, you have to actually live in the property and own the property, right? Own it or have an interest akin to a life estate, which can include having a 99-year lease or something like that. Whatever rights that someone would have as to their homestead are protected. I want to clear up the confusion here because homestead means 3 different things in Florida. Number one, the creditor protection exemption, which in my view is probably the easiest one to qualify for. Own the house or have some sort of substantial interest in the house and actually live there, reside in the house, have a subjective intent to make it your permanent domicile and actually live there. And it can be your homestead for Florida creditor protection purposes, notwithstanding that Washington State or New York or California thinks that you still live in those states. But it's really important to get that cleared up. The second aspect of homestead that we'll talk about later is property tax. That you have to file an application for, and that gets you a property tax benefit that's a little different from the creditor protection. It's important, of course, however, it's completely different from the creditor protection for homestead purposes. Now, we talked earlier about the city limits and outside of city limits. That is the number one thing I think with homestead. And again, here are the other distinctions between the homestead exemption for property tax purposes, where you're going to save $1,000, maybe a little more of taxes each year, which requires that you file an application initially and actually live in the house on January 1 of the year in which you want the homestead exemption to apply. It doesn't mean you have to be in the house physically, but you have to live there and you have to have a subjective intent to reside in the house as your principal residence. So don't go canceling your New Year's cruises yet. You can still take them or go on vacation if you want to become a Florida homesteaded individual for property tax purposes. But keep in mind that you have to live there and you have to own the interest. You can't just buy a house in Florida, come in October, leave, never to return. It has to be a subjective intent to have it be your homestead. So I'm going to skip over some of these other more detailed aspects here, but I do want to say that homestead is protected from just about every creditor except for a few important ones. Number one, the IRS or any federal agency that allows a statute where federal law can trump state law, like the IRS or the SEC or the FCC, that is a super creditor, as they're called, and they can pierce homestead exemption in Florida. Number two, anyone to whom you've knowingly and voluntarily given a lien on the house. So the mortgage I have in my homestead, I can't tell the bank to go take a long walk off a shore pier. I have to deal with that as a valid lien against my homestead because I knowingly gave a mortgage against my house. Number three, a mechanics lien, which is something that, I put a new pool in my house, I get a new roof, something like that. The labor persons who do the work can file a notice of commencement on my house, and they can take a lien on the house. And then the fourth exception is something that's not necessarily in the Constitution or statute, but is more creature of equity in court cases, and that is ill-gotten gains. And I skipped over a minute ago the Buffani case, and that was a case that had a fact pattern where a homestead property was purchased with ill-gotten gains, meaning that fraudulent activity was used to acquire the assets that ultimately went into the purchase of the homestead. By using that, or by having ill-gotten gains go into the homestead, you're not availed of the creditor protection advantages of homestead. That is really important. Now, Florida has another case called Havico v. Hill, which says that if a creditor is chasing you and on the 11th hour, you take your assets and put them into a homestead, that homestead is still your homestead. There's no fraudulent transfer as to that creditor. However, if it's ill-gotten gains, or if you have proceeds that were acquired by reason of the debt, for example, I borrow money from the bank and I take those monies and it's directly traceable and I put them into the new homestead, it's pretty likely that the homestead protection is not going to apply as to that creditor. That is a trap for the unwary and something to consider before we tell our clients that there's this absolute homestead protection in Florida for creditor protection purposes. Another wrinkle in Florida homestead law is this idea of confidentiality. Several times a year, we'll get a client that will reach out to us and say, I'm buying this nice homestead, this huge house, and I don't want my name to appear in the public records. So what we've done before is typically set up a situation where we have a revocable land trust own the homestead, have the title to the homestead, and the trustee of that trust be a Delaware or a Colorado or a Wyoming LLC that doesn't have like a Sunbiz style page where you can look up the names of the individuals who are affiliated with that LLC. What that means is that if I buy a house under a land trust arrangement and have ABC LLC become the trustee, anyone who searches for my name in the public records isn't going to see my name show up. It's going to see nothing. And that's kind of what we're shooting for here. Even though my spouse and I own the beneficial interest in this land trust as tenants by the entireties and can get the homestead exemption under the Florida property tax and creditor protection law as a result. This is a really nice little tool, little nuance that can be taken advantage of. And you'll see here, this can be a way to hold in rental houses where you have a revocable trust and an LLC in place. There's certainly a lot of things that can be done using these land trust type instruments. They're very helpful here in Florida. Sometimes they're called Illinois land trusts because that's where they originated. But I certainly recommend considering this for the client who wants that confidentiality. So I'm going to skip on down to another area of Florida law called Florida tax law. And before I get too far ahead of my skis, earlier you may be thinking, well, you mentioned 3 homestead components. Well, the third one is restrictions on devise of homestead. And I will get into that in a minute, but I didn't want to leave you hanging. I know a lot of you were just waiting on bated breath at the end of when I mentioned it, just like you were waiting on a cliffhanger maybe for a show before we had streaming. But before we get there, I'll keep you guys hanging. We're going to go through Florida tax law. And Florida is known to not have an income tax. It's a misconception to say Florida does not have a tax. We don't have a state income tax for individuals, partnerships, trusts, S corporations. But C corporations, do have an income tax at about 5.5% of taxable income, but it's deductible on federal tax return level, which therefore reduces the tax rate at the federal level to 25.895% based on the way the math works out. We also have a sales tax on rentals, on commercial rent, and any residential rental that's more than 6 months. Sorry, that should be less than 6 months. That's less than 6 months, based upon 5.5% at the state level, and anywhere between 0.5% and 2% at the county level. Most counties, it's around 6.5%, 7%. That's a really important thing to understand. We also have this idea of documentary stamp taxes. This is one of the most onerous taxes in Florida, and anyone who's bought and sold real estate in our fair state of Florida knows how expensive this can be. Florida documentary stamp tax is generally based upon 0.7% of the consideration paid for the property. And if I buy a house for $100,000, for example, 0.7%, $700 of documentary stamp tax. It's usually paid by the seller, however. It's negotiable like anything, but in most counties and most customs, the seller foots the bill for this documentary stamp tax. I will want to mention Miami-Dade is a little different. There is a 0.6% documentary stamp tax. However, there's a 0.45% surtax on multifamily and multifamily residential and commercial properties. So, this documentary stamp tax can be quite onerous and can form a really big trap for a lot of individuals. It also applies to notes and mortgages when they're signed and delivered in Florida, excuse me, or mortgages recorded on Florida real estate. Here is one trap. If you transfer property in Florida that's subject to a mortgage, then you can have the outstanding balance of the mortgage trigger a documentary stamp tax for 0.7%. In essence, if I own a parcel of real estate in Florida that has a $100,000 mortgage, it's immaterial what the value of the property is. If I convey that property as a gift to my son, well, despite the fact that it's a gift and gifts are generally exempt from Florida documentary stamp tax, because there's a $100,000 mortgage on that property, a $700 documentary stamp tax would apply on that transfer, even if there's no consideration flowing back the other way. Really important and a pretty common misconception, because in Florida, when you transfer real estate into a wholly owned LLC, so if I own real estate 50% and Alan owns it 50%, and we get together and we put 50% interest into an LLC owned 50% by us, if there's no mortgage under a case called Kiro, there's no Florida documentary stamp tax. But if there was a mortgage on that property, we pay documentary stamp tax on the value up to the outstanding balance of the mortgage, even though we're getting the same consideration back. We're getting 50% ownership in an LLC that owns the property. Really important, a really big trap here. And you can avoid it by going offshore. And you can do so by either taking a boat or a plane, or having an agent in a different state sign the documents and accept documents outside of the state of Florida. So really an avoidable tax on some things. If it's a Florida mortgage, or if it's Florida real estate that's being transferred, then you really can't do any of this. You have the documentary stamp tax to apply, but on a mortgage that's not secured by Florida real estate, you can avoid documentary stamp tax in this manner. You also can do some type of family loan that doesn't have a mortgage. And how this would work is the property goes into a land trust. The owner of the beneficial interest of the land trust can be the same person who would have owned the property. And instead of taking a mortgage on the property, a pledge agreement of the or security interest in the beneficial interest of the mortgage are what's taken by the lender. Therefore, you don't have to file a mortgage and you don't have documentary stamp taxes. You probably wouldn't use this in an arm's length scenario, but you certainly can use this if you have a friendly loan in place. it's very helpful to avoid this documentary stamp tax. And then, of course, what about property taxes? And those of you out there in places like New York and California will be laughing at us down here in Florida, sarcastically, of course, when you see what our property tax rates are compared to yours. But we still have property taxes here, and they can be somewhat substantial if the value of the property has grown in recent years, or if the property is in a municipality that maybe has a little bit higher tax rate than, say, something outside of a city limit. Of course, with homestead, you get $50,000 off the top of the assessed value under the homestead exemption for property tax purposes. And you also get the ability to have your assessed value on the house, on the homestead, not increase each year by more than 3% or CPI, whichever is lower. So that's really important. That's another reason why the homestead exemption for property tax purposes can be very beneficial. We talked already about how to qualify for the property tax homestead exemption. There's a way to port that homestead exemption. You can move it to a new house if you upgrade or even if you downgrade, so that you get the benefit of that cap each year. We call it Save Our Homes, and it was enacted really to prevent folks who've owned property, beachfront property, for years and years. And as Florida's become a more popular destination over the years, if the values have increased, their property tax bill doesn't go up exorbitantly. It's limited. So even though the value may go like this, you have the property tax value lower at this level. And that space in between is the tax savings that can be ported over to your new house based upon somewhat of a complicated formula to enable an individual to not necessarily get pulled into a lot higher taxes on the second tax year after they purchase the property. And I say that because another little trap here, I don't have a slide for it, is that when you buy a house in Florida, you have the tax classification of that property as of January 1 of the year. So I moved to Florida, I buy a house from someone, it was their homestead, but it's not my homestead. And I say, wow, look at these taxes. I'm paying $2,000 a year in taxes. They had the homestead, they were longtime owners, they had the Save Our Homes in place, so their property taxes were low. Well, because I bought the property for a much higher value now, it will be reassessed as of the next year, and therefore I'm going to be paying a lot more property taxes. That's a trap for a lot of individuals moving to Florida. That they don't recognize that their taxes are going to go up somewhat substantially if they purchase the home, and that's really not avoidable. I mean, the property is going to be reassessed on a sale. And we have here some exceptions on the portability. I'm not going to dive into them here. But another little nuance to be aware of is this idea of getting the homestead exemption when the house isn't even owned. And we do this for clients who say, I own this house, my mother-in-law lives there, I don't want to give her the house, but can she qualify for homestead? And the answer is probably. And the way to do so is either put it into a trust for her benefit, give her the right to live there for her life, and that will qualify for the property tax homestead exemption. Another way is to have a bona fide 98-year or longer lease in her rights, which could be terminable, on her death. And there's no requirement that rent is paid, but if there's a 99-year lease in place, homestead exemption could apply to the property and can generate that $1,000 or more tax savings each year. And then, of course, giving someone a life estate in the homestead. So, you can even have an elderly parent get a life estate, or for estate tax or income tax planning purposes, it might be a good idea to give some ownership or give that family member a power over the property to hopefully get a step up in basis on that individual's death. But just because the house isn't owned by someone doesn't mean they can't get the Florida property tax homestead exemption. Common misconception that we will hopefully avoid. And we have language here. This is our trust language for a trust beneficiary to get the homestead exemption for property tax purposes. And then we have additional language that can go into a homestead trust. Another trap with homestead is this, with property taxes, is this property tax 10% cap each year. For non-homestead property, any such property for tax purposes, for property tax purposes, cannot be reassessed at more than 10% over the prior year value. So in essence, I buy a property for $100,000. Its taxable value is $100,000. We'll just say for argument's sake. The next year, it can't be more than $110,000, and so on, 10% each year. However, if and when I sell that property, or I transfer ownership or control of that property, I transfer 50% or more interest, or I put it into an LLC that I own 100% of, that can trigger reassessment. A lot of attorneys out there, present company included, have long trumpeted the benefits of using limited liability companies to own real estate. Right? That was something we've done for creditor protection purposes. It's a sound piece of advice. But if the property's been owned by the client for a long time, putting that property into the LLC can implicate the removal of this 10% cap. And that can cause adverse property tax consequences. One thing we've experimented with is using a trust, because a transfer to a trust that's revocable by the client does not necessarily cause this 10% cap to go away. I also want to mention that improvements to the property, substantial improvements to the property, could trigger this cap being removed. And you'll see here as I get down to the changes improvements slide here on slide 55. If you buy a vacant lot, for example, and you build a house on it, well, it's going to be reassessed. Or even if you buy a tear down and build it up to the point where it's way more valuable, you can have that the reassessment occur and the 10% cap go away. Really want to stress that, because it's not something a lot of attorneys and advisors know about, and it's really important for clients to be aware of if they're contemplating transferring ownership of property or making substantial improvements to property. All right, so now the limitations on devise. We finally get to resolve our cliffhanger from just a few sections ago. I want to mention that, homestead, again, the three things: creditor protection that we talked about, the property tax exemption that we talked about, and then the ugly red-headed stepchild, the demon of homestead, are the devise limitations. And I say that is because these devise limitations can put a wrench into estate plans if not appropriately considered. I cannot stress this enough. And the way this works is as follows. If a Florida resident dies with a homestead and is survived by either, not both, either a spouse or a minor child, they cannot transfer their homestead on death, with one exception. If they're survived by a surviving spouse and the surviving spouse, there's no minor child, they can leave the homestead outright to the surviving spouse. They can't put the homestead in trust for the surviving spouse. If they do that, then there's going to be this wrinkle of forced devise of homestead, in which event the surviving spouse gets his choice or her choice of a life estate in the house, the right to live there for life, with the remainder interest then going to the descendants of the decedent equally, or a 50% tenants in common interest, with the other 50% going to the decedent's descendants. This is really big, because if I, for example, die with an 8-year-old child, I can't leave the property as I want, meaning that my wife at the time, if I'm married, gets a life estate or 50% tenants in common interest, and my 8-year-old child gets the other half. If I had a minor child, right? If I had a minor child with an ex-wife, and I don't want my ex-wife anywhere near my assets, this can be a huge problem, because now I have my ex-wife making decisions for my 8-year-old child as to the interest that he inherited. This is a really big wrench. Now, the surviving spouse can execute a waiver. In fact, under new Florida law, can execute a waiver by signing a deed that has this special language, this indented language here on page 58, that says, if by joining this deed, I waive my homestead rights that prevent my spouse from devising the homestead to someone other than me. If there's a minor child involved, Doesn't matter. This isn't going to save your bacon. You know, it's really important to consider the implications here and let the client know that this potential devise restriction can apply. I also want to mention that if you have a spouse and minor child surviving a decedent, the homestead can be owned as tenants by the entireties. We'll get to that in a minute, but really what it is a survivorship type ownership where on one spouse's death, it automatically goes to the other spouse. That is allowed. That is a valid devise because the form of ownership is what lets it occur. One way to get around this is to give a spouse who's on their deathbed maybe a life estate and have the other spouse receive ownership in the property because nothing in this homestead law prevents a devise or a transfer during lifetime if the spouse consents. Now, homestead law is also structured to the point where I can't go out, transfer my homestead during my lifetime without my spouse's consent. Every transfer of a homestead of a married person during lifetime has to have a spousal consent unless the spouse has executed the waiver. Another little nuance to be aware of here that's not really as well known as it should be given the gravity of it upon estate plans. Now we have other homestead strategies we kind of talked about here. I want to jump into another item of Florida law that doesn't necessarily get a lot of fanfare, and that's the elective share. Elective shares is a right of a surviving spouse to claim approximately 30% of a deceased spouse's estate. That is, granted under Florida statute by reason of marriage in the event that the surviving spouses waive their elective share rights. It doesn't apply. But the way the elective share works is generally the assets in the decedent's estate form something called the elective estate, and it's somewhat complicated, but it's generally the assets owned by the decedent, including assets that were given away within the year before. So you can't just give all your assets away before death so as to avoid the elective share. Now, this 30% elective share right is based upon the value of the assets, and there's a host of rules as to how each asset's valued. That 30% would have to go outright. But what someone can do is say, look, I'm going to fund a trust for my spouse, and that trust gives the spouse the right to receive distributions of income plus principal as needed for health, education, maintenance, and support, only after taking into account her resources available. My kids are going to be trustee of this elective share trust, and as a result of that structure, the statutes value the assets going in at 80% of what they would otherwise be worth. Here's an example. In my fantasy world here, I die with $1 million of assets. My elective estate is $1 million. My spouse makes an elective share election. 30% of the assets, $300,000, have to go to her. Well, if I said fund a trust for my wife with the minimum amount necessary to satisfy the elective share, it meets the elective share trust requirements, this bullet point 2 is satisfied, those assets going in are valued at 80% of their value. So if my personal representative transfers a brokerage account with marketable securities into that trust, well, it has to be worth $375,000, right? 37.5% of the million, not 30%. And that's a function of essentially 30% divided by 80% equals 37.5%. It's more money that goes into the trust, but I can provide under this elective share trust that when my spouse dies, the assets in the trust go to my desired beneficiaries. This is in purely hypothetical. With today being my wife's birthday, certainly don't want to imply that I'm trying to disinherit her or want to leave anything away from her. But this tool has been used for a number of clients, especially in second, third, fourth marriage situations where clients want to reduce the impact of the elective share upon their death. So this is a very important but not well understood rule under Florida law. And we have a lot more slides here, including one that is really helpful. If you have a client who has assets that have been in a trust at all times since the earlier of October 1, 1999, or when the decedent was married to the surviving spouse, and if it was always a non-marital asset, then those separate trust assets are not counted as part of the elective estate. And that's a really great loophole. We've used this before to have, I would say, a 50% reduction in a client's elective estate because they had assets in a trust that have always been non-marital since before marriage. So take a look at the elective share code. It's Florida statute section 732.2025, around that area. 2055 certainly describes the valuing of these assets. Another little trick here, if a client wants to minimize the impact of elective share, have a retirement account, an IRA or a pension account, go to the spouse, because the statute says value those assets at their fair market value for tax purposes, which is whatever's in the account. I have $1 million IRA, it's worth $1 million for elective share purposes. But if I leave it to my spouse, she's got to pay built up income tax on that. So to her, it's not really as high as $1 million. It's another way for a decedent to reduce the burden of the elective share. Very important to consider. I think that this is not something that is really understood, especially if you have a blended family in place here, or you're doing work for a blended family. And I'm going to skip ahead to tenants by the entireties to resolve yet another cliffhanger. So tenants by the entireties is a really unique form of ownership in Florida where you can have joint tenants with right of survivorship, essentially, except that the assets owned in this manner generally are protected from the creditors of only one spouse. I'm driving a car. My wife does not own the car. My wife has nothing to do with the car accident. I get sued as a result of the car accident that I'm in. Any tenants by the entireties assets that we had before the accident should be protected from my creditors. They're not protected from joint creditors. So again, my wife and I gave a mortgage on our house. The bank forecloses on the mortgage, comes after us for a deficiency. Well, in that case, we can't tell them that tenants by the entireties applies. We can't stonewall them and prevent them from stepping in to reach those assets. And there's some quirky rules here for tenants by the entireties. 6 unities have to exist. So you can't just say, hey, it's tenants by the entireties, and when I die, I don't want it to go to my spouse. I want it to go to a trust for my spouse. It doesn't work that way. You have to have this ability where on death, there's survivorship so that I die, it goes to my spouse. We both have to have joint ownership and control. We have to have a unity of interest. In essence, we have a similar overlapping 100% interest in the property under this legal fiction for tenants by the entireties. And then, of course, unity of time. It's prudent to have a tenants by the entireties account established separately from a new account being retitled, because the spouses must acquire the asset simultaneously under the same document. Some commentators think that one spouse can't transfer assets to both spouses for tenants by the entireties. It has to go to a straw man, like a revocable trust or something like that. I don't know if I agree with that position, but if you want to be extra safe, that's one way to do it. And then, of course, they have to be married, right? I mean, that's, non-residents who own real estate in Florida can claim tenants by the entireties immunity, but by and large, you want to make sure that the clients are married, of course, to have tenants by the entireties, and these unities are followed to have the protection apply because of how important it can be, right? We talked a minute ago about the straw man, and again, tenants by the entireties is very important, from a creditor protection standpoint. I tell practitioners and clients who consult us in this area, don't be cutting corners, because you want to make sure that you have that tenants by the entireties protection if you need it. Okay, so then we get down towards some of the end of our presentation here, some of these nuances, and this last one involves a little bit of exploration of Florida trust law. And those of you who see the PowerPoint deck and think, wow, there's another 60 odd pages left, we're not going to cover every page, but I do want to highlight some of the important items here that are misunderstood under Florida law and that you can take and use in your practice. And one of which is Florida's new SLAT law. Now, a SLAT is a fancy way to say an irrevocable trust that one spouse creates for another trust. It's very much a blank canvas. It can be drafted in any variety of ways. It is widely used for estate tax planning and for creditor protection planning to boot. I think it's really important and helpful in a lot of situations to have this type of trust. And one of the important things in preparing a SLAT is making sure that, of course, you have a married individual, you have assets that are transferred or sold to the SLAT. The spouse is a beneficiary of it, and one of the key components is, will the grantor be a beneficiary of the SLAT, and if so, how will that occur? And that kind of goes hand in hand with the next question of selecting a jurisdiction for the SLAT. There's about 30 or so asset protection jurisdictions. I'm sorry, about 10 or so asset protection jurisdictions in the states here in the United States, in addition to the offshore asset protection jurisdictions like Cook Islands and Nevis. But Florida is not one of these domestic asset protection jurisdictions. So in states like Nevada, South Dakota, Delaware, Alaska, I can create a trust for my benefit. An irrevocable trust benefits me, benefits my spouse, my kids, and my creditors under those states' laws cannot access my assets, assuming that I didn't make a fraudulent transfer. And that is really a transfer at the last minute. I put these assets in well in advance for a rainy day. Well, Florida does not have such a law. We do not have a self-settled spendthrift trust law. It's very clear that we don't have it. What we do have is this new law that says, if I create a SLAT, so a trust that benefits my wife for her lifetime, and if the trust says I can become a beneficiary only after her death, not before, not on divorce, not if I'm destitute, not if snowflakes start to fall out of the sky in Florida, only after her death I can become a beneficiary, then for Florida state law, she's considered to be the settlor, the grantor of the trust on her death when the trust comes back to me, meaning that my creditors shouldn't be able to reach into the trust at that point after her death. I don't know if that works from an estate tax perspective, an estate tax planning perspective. It probably doesn't. But this new Florida SLAT law allows for a boomerang type trust where a grantor can be added at the end of a trust where the other spouse has passed away. So, this trust has to be irrevocable. It has to be a trust that contributions to it are completed gifts. It can't be an incomplete gift trust where I put assets into it and I can make changes as to who the beneficiaries are. It has to benefit the beneficiary spouse during lifetime, right? She has to be a beneficiary of my SLAT that I create. I can't say that she's not a beneficiary. And I can't be a beneficiary until after the fact, until after her death. Huge loophole here, or huge problem, I should say, because a lot of individuals who look at this say, oh, I'll just make the grantor spouse a beneficiary after the first spouse and the grantor spouse divorce. That's not going to work. That's a huge mistake. All right, that's certainly not something to consider when you're drafting this type of SLAT for this new law. Another thing to consider is that when assets go into this trust, there are in Florida generally exception creditors that apply. So even if I put assets into this trust for my spouse and my kids, those assets are not absolutely protected from their creditors. In fact, any alimony judgment or child support judgment for last resort purposes, the trust assets can be used to satisfy those judgments for last resort. Any IRS issue or federal super creditor issue, the FCC, the SEC, those assets can be used to satisfy those judgments. And then, of course, one that benefits us lawyers is anyone who helps set up the trust can have their bills paid from the trust. It's not like one of those scenarios where the bad guy in a movie hires the contractor to build this big extravagant lair and they get taken off screen essentially. It's one of those things where if you help set up this trust that's impenetrable or almost impenetrable, I should say, then you can get paid from the trust assets. But I cannot stress enough that it's important to make sure that you have the grantor spouse not be added as a beneficiary during the grantor spouse, the beneficiary spouse's lifetime. Very, very important. I also want to add, this new law is an extension of prior law where a lifetime Q-tip trust or a lifetime marital deduction trust with the general power of appointment, this law applied under those scenarios where, for example, I set up a trust for my wife. It's a lifetime Q-tip trust. We make a Q-tip election on a gift tax return. And that trust says on her death, it can come back to me. Under prior law, under Florida law, those assets that come back to me in trust should be protected from my creditors, subject, of course, to the exception creditors that I just mentioned. From an estate tax planning standpoint, that's probably a bit stronger because those assets under a lifetime Q-tip trust are going to be in my spouse's estate for federal estate tax purposes. And also, of course, with the first one here, the life estate general power of appointment marital deduction trust. The irrevocable trust that I've been talking about, this slat that's designed to be outside of the estate tax system, it's not as clear whether those assets would be subject to estate tax if they come back to me. But I think Florida law has clarified the fact that my creditors can't reach into that trust. And maybe one way to handle this would be to structure it so that I can't get added back unless I have the net worth that's been reduced down to a certain level. This, of course, is after my spouse's death. Or I can't get added back until my spouse exercises a power of appointment in my favor, which is a way that you can typically do this. And I think that gives you a little bit more protection for this slat law. I'm going to say it for the 7th time. Make sure that if you use this law, the grantor spouse would be added as a beneficiary in the event of the death of the first dying of the beneficiary spouse, not in the event of divorce. This is a situation where we can see a mistake will be made by a lot of people who don't know the intricacies and nuances of this law. We want to make sure that the beneficiary spouse is always going to be a beneficiary during his or her lifetime. You can't have a provision that says beneficiary spouse and I divorce, she's no longer a beneficiary of this slat. Another important concern here. And then finally, we want to make sure that we have a slat. If we have a slat that requires that distributions be made or gives discretion to make distributions to the grantor spouse for tax reimbursement purposes, that could be problematic and throw us outside of the statute. Really important to consider this under these Florida boomerang slats. These are really pretty easy mistakes to draft around, but they're very high impact events. So I would suggest taking due regard when drafting this type of trust. And then, of course, we have some other considerations here. Will a grantor spouse be a little bit more trigger happy on pulling the plug on a beneficiary spouse to be added back? Time will tell. But it's certainly a good idea to have restrictions put in place and have the trust drafted to comply with the law if you're shooting for these benefits. Now, what we're doing a lot of is using other jurisdictions that have a little bit more well-settled law, places like Nevada and South Dakota, those self-settled spendthrift trust jurisdictions that I mentioned. We typically would say that the grantor spouse cannot be added unless or until a committee of independent trust protectors adds the spouse back as a beneficiary, and only if the grantor spouse's net worth drops below a certain level, that net worth requirement is somewhat of an act of independent significance that can really beef up this provision or beef up this protection, because the grantor is not going to give away assets just to become a beneficiary of a trust, a discretionary beneficiary at that. And some of the language that we use here on slide 94 and 95, this talks about how we bury language in the middle of a trust protective paragraph where a descendant of the mother of the grantor can be added as a beneficiary, but only must be an individual who qualifies as an independent trustee from a net worth standpoint. Very convoluted language, as you can see. Take an Advil and then read it would be my recommendation. And then you go to the next slide here, pop another Advil, and what you can see is the independent trustee definition is limited to attorneys with 10 years experience who are an AV rated individual in Martindale Hubble, or someone who has a net worth of more than $6 million. So our client who's worth $50 million here could be added back by a committee of independent trust protectors consisting of his best friend, his CPA, and his brother-in-law, who he gets along with very well. And he can only be added back if his net worth drops below $6 million. That act in and of itself is so independently significant that I think it helps provide additional layers of creditor protection and estate tax protection that you might not have using a Florida slat. All right, so then I'm going to jump us down to the last item on my list here for today so we can go about the rest of our July 8th, and that is community property. Now, Florida now has a new Community Property Trust Act. When I say new, I mean it's 2 years old. Came out on July 1, 2021. And what it does is it allows Florida individuals, or better yet, it allows anyone, as long as you have a Florida trustee, and we'll get to that in a minute, to effectively opt into the community property trust regime by having a community property trust in Florida created to own property. And some of you are thinking, well, why the heck would you ever want community property? Well, one benefit of community property is under Internal Revenue Code section 1014B6. Any individual who dies owning community property, and that community property is in their estate, the entire property that's subject to the community property gets to step up in basis. Here's how this works. I buy stock for $10 a share. I live in Washington State, which is a community property state. My wife and I buy it. We each own one half of the community. On my death, assets are included in my estate to the extent of one half. However, there's a full step up in basis as to the value of that stock on my death, notwithstanding that only that one half is included. So if the stock is worth $100 after my death or on my death, and my spouse sells it the day after my death, then she pays no income tax if the sale occurs for $1 million. This can save a lot of income taxes. The basis goes from 10 to 100. A tremendous amount of income tax here. And by using this community property trust, it is believed that an individual can gain a much higher level of income tax avoidance or basis to avoid income tax. And that's why a community property trust has some utility. But does it really? And I'm going to jump down here to this idea of why you would have a step up in basis and would it actually work? Well, in certain aspects of trust law, the IRS has said if it's an opt-in community property trust, we're not going to recognize the full step up in basis. In fact, there's an IRS publication 555 that says it's not going to address the federal tax treatment of income or property that's subject to a community property election under Alaska, Tennessee, or South Dakota. Now we can add Florida to the list because Florida, of course, is this opt-in system. So it's not necessarily clear that community property trusts are going to work for their intended purpose in Florida, but it certainly is a better positioning for that step up in basis than what might apply if tenants by the entirety's assets or assets were owned as tenants by the entireties. That said, the creditor protection implications of community property are far inferior to what tenants by the entireties provides. For example, in a lot of states, Florida included, and forgive me for bouncing back and forth here, the creditors of the assets are going to be, or creditors of one of the spouses are going to be able to reach the assets, at least one half of the assets, to satisfy a judgment. There's some states that are creditors can take all. Other states are one half of the property. In Florida, I think it would be one half based upon this idea that you would have one half owned by each spouse. Now, if you have both spouses, it can be the entire community property trust assets that can be used to satisfy the creditor claim. I do want to mention the requirements really quickly. So we have to have that the trust is a community property trust under the section 736.1503, has to have one trustee who is a Florida resident or a Florida trust company that's authorized to transact business in here and act as a trustee here in Florida. And then, of course, both spouses have to sign it with the formalities of the execution of a trust, which good practice is 2 witnesses and a notary public. And you have to have this bold, conspicuous, all caps language at the beginning of the trust, because there are substantial requirements that apply, or implications, I should say, that apply on death as to community property that might not otherwise apply under a tenants by the entireties or non-community property regime. This act is out here. It's been 2 years, as I said. Since then, we have drafted 0 community property trusts. At least I've drafted 0 community property trusts. And that's because, you know, there are better ways to get a step up in basis. We like the Jest Trust, J-E-S-T, Jest Trust. And here's a nice comparison of the two. The Jest Trust is a mechanism where spouses put assets into a common trust agreement. There's separate shares kept under the trust agreement. On the first death, the first dying spouse has a general power of appointment over all the assets in the trust, and that can cause the assets to get a full step up in basis on the first death. It's probably not as assured of a step up in basis under the Jest, but after the first death, you get larger creditor protection that you wouldn't get with the community property trust, and you potentially can have a much more streamlined administration, especially if you have community property that is, you know, elected as to certain assets, and it's not clear whether assets are titled in that manner or not. In any event, Florida Community Property Trust Act is there. It's something that's not really well known. It's probably not as widely used as maybe thought, especially because things like homestead. We talked about the restrictions on the buys. If a homestead goes into a community property trust, it's probably not going to work unless you have a waiver from the spouse or there's no minor child that survives the decedent. Again, just a little nuance, for something for us to cover. I will be back at some point in the future to give a presentation on Jests in and of themselves. We can talk about them for hours. But today I hope that you got a great survey of some of these wrinkles in Florida law that may not be evident or maybe misunderstood. I certainly appreciate you joining us this Saturday, and you can tune into us next week. I think we'll be back to our regularly scheduled programming with Alan joining us. I believe next week he's talking about investing in European bank accounts and having a Swiss banker on the line with us, which will be great for all attending. Until then, I thank you guys very much and wish you a wonderful Saturday, and appreciate your attendance and feedback.